So good morning, everybody. I think people are still joining, but people can get connected just while I'm sort of doing a bit of an introduction. Really pleased to see you all here for our 5 in 25 webinar. And today we're looking at contract changes under the Procurement Act. And that's an area of procurement law which we advise on all the time. But I was thinking this morning, although we do a lot of it, it never gets boring, it never gets formulaic, as in fact all contract changes are very individual, both in terms of the modifications being made and the wider context in which they're being made. So no one piece of advice is ever quite the same as another. And of course, with the change from Regulation 72 of the PCRs to Section 74 of the Procurement Act, we've got a whole new regime to keep us happy and occupied. Quick introductions before we get started. Many of you will know me. I'm Jenny Beresford-Jones, Senior Legal Advisor and Public Procurement Specialist in the team here at Mills and Reeve. I did have a short foray into the world of procurement litigation last month with our litigation colleagues, but today I'm safely back in non-contentious territory, which is my comfort zone. So I'm here with Shailee Howard, who's the partner who leads our non-contentious procurement team, and also with Rona McPherson, who's a principal associate specialising in procurement and commercial contracts. And I know that both Rona and Shailee love nothing more than a Regulation 72 advice note, so they are very well placed to talk to us about contract changes. Just in terms of housekeeping, we've got lots of people still joining us today. So the session is being recorded, and that recording and the slides will come around after the event. If you've been to one of these before, you'll know that we don't take questions live in the webinar in order to keep to time, but we do address as many questions as we're able to in a Q&A document, and that will come around as well after the event, together with the recording and the slides. If you've got any difficulties technically, you can't hear us or you can't see, pop a note in the Q&A as well, and Sarah will try to help you. And finally, at the end of the webinar, a short feedback form should pop up. Be really grateful if you could complete that, as it helps us to design our webinars and make sure that they are interesting and relevant to you. So just before we get going, the latest on reform and the timetable there. Of course, it's election day today. Hope you managed to vote today if you wish to do so. And as we know, the announcement of the election hasn't changed that implementation date, 28th of October 2024. Although I do wonder if perhaps it's slowed down that publication of some of the government guidance that we're waiting for. So I think the original aim was to have published it all by the end of June. That target's not quite being hit. Having said that, we did get 3 extra pieces of guidance this week. I think it was on Tuesday, on modifying procurements, time periods and assessments of competitive tenders. So by my reckoning, that makes 22 pieces of guidance published, 26 pieces of guidance still to come, and that includes the guidance on contract changes. So of course, relevant to this webinar, we'll all have to review that once it's available. And the link to the guidance is on the slide there. And I think that's all I need to say by way of introduction, so we can get started on our first question, which is really sort of going back to first principles, really. This tricky question: I'm making a modification to a contract. Should I use Regulation 72 of the Public Contracts Regulations or Section 74 of the Procurement Act? But the way we're going to deal with this is that I'm going to give Rona some tricky questions, and hopefully she's going to tell us which piece of legislation we should be using. So let's imagine for a moment that it's the 1st of January 2025. Hopefully we will not all be at work on New Year's Day, but just let's imagine for these purposes. We're sitting at our desk and we've got 3 contracts that need modifying. The first one, we can see that it's a contract dated 25th of October 2024. How do we know whether we're under the PCRs or the Procurement Act? And I think Rona may be able to give us a steer on that.
So a contract dated 20th October 2024, as that contract would not have been procured under the Procurement Act, but under the Public Contracts Regulations, or the Concessions Contract Regulations, or the Utilities Contract Regulations, then any modification would need to satisfy those regulations. This also means the notice requirements would be those set out in the relevant regulations, and we don't have to consider what's in the Act.
Okay, thank you. And then the second thing that I've got on my desk it is actually a call-off contract, and that one is dated the 1st of November 2024. So it's 1st of January 2025 now, but I'm looking at a contract which post-dates the coming into force of the Procurement Act. What would we do with that one?
Well, although the contract was entered into after the Act came into force, the procurement for that contract would have started before that. Therefore, it's the legislation that applied to the procurement for the call-off contract, for example, the PCR, that will continue to apply here.
That's interesting. And then, so let's make it another level of complexity. This time we're modifying an actual framework agreement. And that framework agreement is dated the 1st of December 2024. So that's after the Procurement Act comes into force. Does that mean we have to do it under the new regime?
Well, the agreement was entered into after the Act came into force. However, again, the procurement would have started before then. You might be wondering what I mean when I'm saying started. For procurements requiring a contract notice, the starting point is the submission of the contract notice for publication by the authority. For a direct award, it's the time when the authority contacts the relevant contractor, notifying it of the authority's intention to enter into a contract. Full details of this can be found in Regulation 5 of the Procurement Act 2023, Commencement Number 3 and Transitional Saving Provisions Regulations 2024.
Wow, that is one piece of legislation, isn't it? So, and just to sort of throw a bit of a curveball, going back to that first contract, so the contract dated 25th of October 2024, let's just say that that contract is for something like diagnostic radiology services. So it's perhaps it's an NHS contract, it's clinical healthcare. Does that change your answer?
Well, if your contract is for healthcare services, as is the case here, since the 1st of January of this year, these must now be procured under the Healthcare Services Provider Selection Regime Regulations 2023, known as the Provider Selection Regime for short. And it is the provider selection regime and those regulations that will apply to any modification of a contract for such healthcare services, even if your contract was entered into prior to the 1st of January under the PCR. So for healthcare services, it's pretty clear cut.
So that's interesting, isn't it? So there's a slightly different approach under the PSR than there is under the Procurement Act. So if anybody listening is involved in the procurement of clinical health services, that's something to keep in mind. So having had a look at whether we are under the sort of old regime or the new regime, let's have a look at the sort of tricky questions of what modifications are actually permitted under the Act. And I think Shailee can talk to that question. Thanks, Shailee.
Thank you both. Good morning, everyone. So yes, I will look at the concept of permitted modifications under Section 74 of the Act. So Section 74 says that an authority can modify a contract in 3 scenarios, and I've got them on the slide there. But firstly, I wanted to talk about this new concept of a convertible contract. So this is a contract that will become a public contract by virtue of the modification. So for example, you may have a contract that was below the relevant threshold, above which the Procurement Act would apply, but however, through the modification, the authority is increasing the value to make it turn into a contract that is above the financial threshold. And in that scenario, that contract would be a convertible contract and the authority would need to apply Section 74. the government e-learning has confirmed that Section 74 won't apply retrospectively, so it won't apply to any changes from before the contract became a converted contract. It only applies going forward. So that's quite an interesting broadening, I suppose, of the coverage of Section 74. So let's have a look at these three scenarios then. So the first scenario is where there's a permitted modification, and those are set out in Schedule 8. In general, these broadly sort of replicate those that we currently have in Regulation 72. There are some additions, which Rona will talk about next. But it's worth just noting a couple of key changes. So again, Rona will talk about changes to how the value of the modification is calculated. So that's a difference. There's also the ability to make successive amendments. The guidance confirms that separate modifications are permitted under different grounds. And it seems to us that this has always been the case, but it's specifically sort of called out in the guidance. And also there's a general sort of changing to the wording of certain grounds, and the guidance says, well, this is to make the rules more simple to understand and apply. So query whether it does actually change the meaning. And I think this is where the guidance will be really important to aid interpretation of those grounds and to ensure that authorities are applying those in a consistent way. The second scenario is where there's a substantial modification. So this is further explained in Section 74, subsection 3, as a modification that would increase or decrease the term of a contract by more than 10%, where there's a material change in the scope, or there is a material change in the economic balance of the contract in favour of the supplier. So there's a real simplification of the test that we know and love at the moment, harking back from press text days for those of you who are old enough to remember that case. But the idea behind it is sort of largely the same. And then thirdly, we have the scenario where there's a below threshold contract. And as it says on the slide, this can include increases and decreases in the value of the contract. There's still that requirement to ensure that the modification doesn't materially change the scope of the contract. And there's also the proviso that the aggregate value of the below threshold modification cannot exceed the relative public contract value that applies to the contract. So this scenario is very much for those lower value, lower level modifications. So that's a quick trot through what Section 74 and Schedule 8 looks like. I'll now hand over to Rona, who's going to look at Schedule 8 in a bit more detail.
Thank you, Shailee. Moving on to what's new in permitted modifications. As Shailee mentioned, the permitted modifications that are set out in Schedule 8 of the Act. Some of these will look quite familiar, but there are a few new concepts to consider, as Shailee mentioned, and we'll look at a few of these now. Firstly, paragraph 1 of Schedule 8 allows a modification if it's unambiguously provided for in the original contract and the relevant notice, but only as long as the overall nature of the contract remains unchanged. So this is pretty similar to what is currently in public contract regulations, except here it's arguably wider. In the PCR, the change must be clear, precise, and unequivocal. Now it just has to be unambiguous. So in my view, authorities may have a bit more wiggle room here, and we'll see how that works out. Next, a modification is permissible in the case of urgency and protection of life. Now, under the PCR, similar situations allow direct award, but the modification provisions are silent on this. Now, the Act allows a modification if a direct award for the intended modification would be justified instead, either under Schedule 5, which sets out circumstances permitting direct awards, or if a direct award would be permissible under new regulations concerning the protection of life, which can be introduced if necessary under Section 42 of the Act. So jumping back to Schedule 5, paragraph 13 covers direct award in the case of extreme and unavoidable urgency. So the question authorities need to ask is instead of modifying the contract, could we justify a direct award in these circumstances? If so, the modification is allowed. But note, the extreme and unavoidable urgency must not be due to the fault of the authority or be something that could reasonably have been foreseen. Could I have the next slide? Thanks. A modification will also be permitted where it's required because a risk was known about at the time of the procurement, has materialised and now threatens the satisfactory delivery of the contract. So this is covering those known unknowns. The risk in question must not only have been known to the authority at the start, bidders must also have been notified of it in the tender or transparency notice, which should also include that materialisation of the risk will jeopardise delivery of the contract and that potentially there may be a modification under this ground. So we can see that potentially this is going to be quite useful. If the risk materialises, the authority can then modify the contract. However, the risk materialising must not be due to the fault of either the authority or the contractor. Additionally, the materialisation of the risk must prevent the delivery of the contract to the authority's satisfaction. We don't have a definition of to the authority's satisfaction in the Act. However, we'd envisage that this would have to be tied into the contract as tendered. For example, the risk materialising means that delivery timelines cannot be met. Your modification must go no further than is necessary to address the risk that has materialised, so there's no opportunity to sneak in any nice-to-haves along with your main modification. Also, you'll need to show that awarding a new contract to deal with the circumstances is not in the public interest. For example, you could see the time to run a procurement could mean delays to an essential public service, or there could be an additional costs argument. And finally, the modification mustn't increase the estimated contract value by more than 50%. And this brings us nicely to another area that has changed. Under the PCR, when calculating the value of modifications, you have to use the estimated value you included at the start of the contract, and you can't take into account the impact of any subsequent modifications on that value. With the Act, it's the estimated value of the contract at the time the modification is to be made. So that's quite a change. Now, Schedule 8 doesn't actually say that the estimated value is to be calculated at the time of the modification, so don't go looking for it there. However, in the Procurement Regulations 2024, Regulation 40, open brackets 2, close brackets, which lists what must be included in your contract change notice, refers in subparagraph H1 that you must include any change to the estimated value of the public contract or convertible contract, which Shailee explained about, immediately prior to the modification. Therefore, if you've had any earlier modifications that increase the original value, you don't have to worry about them eating into this permissible 50%. Thanks. Now hand back over to Jenny.
Thanks, Rona. That's really, really helpful, isn't it? It sort of quite changes those value calculations quite significantly. My question is moving on from sort of permitted modifications to this question about publishing contract change notices and what you have to put into them. So just to sort of look at where we are currently as against where we're going under the Act. In relation to publication of notices, under the PCRs at the moment, you only have to publish a modification notice in 2 situations, and that's where you're relying on the safe harbours at Regulation 72(1)(b), which is the additional services safe harbour, and Regulation 72(1)(c), which is the unforeseen circumstances safe harbour. And also under the PCR, where you're publishing those modification notices, they're published after the modification is made. And under the Procurement Act, that's going to look quite different. And you'll have to publish a contract change notice for almost all contract changes, unless the change is de minimis. We'll look a bit more shortly at what that means. And of course, the other really big change is that that notice is published ahead of making the change. So currently, under the PCRs, by the time the modification notice is put out there onto Find a Tender service, that change has been made already. And I think that reduces the incentives for bidders to challenge, although of course they could challenge as an unlawful direct award if they think that Regulation 72 has been relied on unlawfully. But wherever the contract change is a done deal, I think that can often be a bit of a hurdle to bidders challenging. But of course, under the Act, the change is needed ahead of making, the notice is needed ahead of making the change. And I think that does change the sort of challenge landscape, as it were. And I'll let Shailee talk a bit more about that later. Just to go on to look a bit more about when do you need to publish a contract change notice, and also what do you need to include in it. Now, I think the thing I really want to get across here is that Section 74, as Shailee and Rona have been talking about, they talk about what contract changes are permitted under the Act. That's one set of tests. Section 75 talks about whether or not you need to publish a contract change notice. And those are two separate sets of tests. And the reason I sort of set that out is that it can be a little bit easy to sort of muddle them up. So let's just have a look at Section 75. When do we need to publish a contract change notice? So you don't need to publish one in various situations. So first of all, obviously, if you make the change, but the value was below the threshold before the change, and it stays below the threshold even after the change, you don't need to publish a contract change notice because it's not regulated by that notices regime. If the value is over the threshold, but the nature of the change you are making is de minimis, you don't have to do a contract change notice. And that's really where there's an increase or decrease of 10% or less in the term, or an increase or decrease of 10% or 15% in terms of the value, depending on whether it's services, goods, or works. And the reason I say to keep Section 74 and 75 sort of conceptually distinct in your mind is that test there looks a little bit similar to the one for below threshold contract changes that Shailee mentioned earlier, and it's sort of easy to muddle them up. So keep them distinct in your mind. The other thing to point out is that if it's a light touch regime contract, so this is really for things like education services, legal services, and any health services which are not in the PSR regime that Rona touched on, no obligation to do contract change notices in relation to light touch regime contracts, even where they're over that threshold. You do need to publish a contract change notice, obviously where the value of the change is more than that de minimis test that's set out a bit higher on the slide. And also, as Shailee said, where before the contract, before the change, it was an under threshold contract, but the effect of the change is to make it over the threshold. That's a convertible contract which has come into the regime, as it were, and in principle that will need a contract change notice unless that de minimis exemption applies. So keeping Section 74 and 75 distinct in your mind, just a word or two on what you actually have to put in your contract change notice. Again, you won't find the detail in Section 75. You have to look at Regulation 40 of the Procurement Regulations 2024, and that really just lists out what you need to put in your notice. So if you're relying on a Schedule 8 safe harbour, which one are you relying on? Why is it justified? What is the change to the term that you're making? What is the change to the value of the contract compared to what it was immediately prior to making that contract change? That's the regulation that Rona touched on earlier. If you've added suppliers or removed suppliers as parties to the contract, that detail has to go in. And you also have to say what date you're planning to make this change and whether you're planning to hold a voluntary standstill period. And I'll let Shailee talk about that shortly. So just to sort of wrap up, as with modification notices currently, I think drafting a contract change notice is something that you probably want to get legal advice on, to make sure that the justifications really stack up. And it's really important, especially if you're going to try to use a voluntary standstill period to provide some sort of defence to any potential challenge, really important that the information in the notice is accurate, not least for that reason, but also to comply with your general Section 12 duties, so to act with integrity and to be transparent in the way that you're publishing information. And that's probably quite a good point to hand over to Shailee, actually, to tell us a little bit more about when can we sign the contract change and how do we know whether to opt for a voluntary standstill period or not.
Thanks,
Shailee.
Thank you. So yes, given that for most scenarios now there is this obligation to publish a contract change notice, I guess a follow-on question, and it's one that we've had in the Q&A, is how soon can I then change? How soon can I then sign that contract change? So there's actually nothing in the Act or regulations that requires you to wait a certain time. So you could, for example, publish the contract change notice and then sort of sign the contract immediately. However, the guidance does allow you to consider whether a voluntary standstill period might be a good idea, as Jenny says. And voluntary standstill periods is a concept that exists sort of at the moment under the procurement regulations, the public contracts regulations, because they're a good way of reducing the risk of legal challenge. And the advantage of having a voluntary standstill period is that if the standstill period passes without challenge, then set aside is no longer available as a remedy to a third party challenger. And set aside is the newly branded contract ineffectiveness as we know it under the public contracts regulations. So of course that doesn't prevent a challenge from arising during the standstill period if the modification is challenged for not complying with Section 74 and a claim form is received during that voluntary standstill period, then in that scenario you would as an authority be automatically suspended from signing that modification. So you could observe a voluntary standstill period following publication of the contract change notice. If you do that, then you've got to say as much in your contract change notice and also set out what the duration of that standstill period is. And it mustn't be less than 8 working days starting on the day that the contract change notice is published. The Procurement Act also protects against the tactical use of a contract change notice and having a voluntary standstill period. So it's section 105, subsection 4, that says that if the notice didn't provide accurate information in respect of the contract change, then the protection afforded by that voluntary standstill period won't apply. And this appears a bit broader than the current case law position that we have from the case of Fastweb, which effectively says that the protection of a notice like a VEET notice won't be available where the contracting authority acts in bad faith, in full knowledge that the contract change or the direct award being made is not permitted. And I think we're going to it's interesting to see that concept has changed in terms of whether the notice provides accurate information regardless of the authority's motive behind setting out those facts. So I think that's a marked difference from the position that we have now. On that note, I think that brings us to the end of today's session. I will pass back to Jenny to wrap up.
Thanks, Shailee. Yes, so it's 10:30, probably time for us to finish. When we leave the webinar, do let us have your feedback. And obviously, as I said earlier, do look out for the recording and the slides and the Q&A document, which we will circulate as soon as we can. The next 5 and 25 is on the 12th of September, so hopefully we will be refreshed after the summer holidays. And just as well, I think, because our next one is on the huge topic of contract management under the Act. So we will need to be well rested to tackle that. So just a big thank you from Shailee, from Rona, and from Reeve for joining us, and hope you found it helpful. Enjoy the BBC Swingometer tonight if you like that kind of thing, and have a great day. Thanks very much, everyone.